All right. Okay. So, we're going to discuss that good old Constitution today. We're going to discuss the right to travel today. And we're going to discuss things that can be done, things that have to be done to get that right back. Look, I love America. We all love America, right? America's great. We got more freedoms in America than anywhere else in the world. Alright? And so we have to love America. We gotta protect it. We gotta stay free, right? But how can we be free if there's nothing we can do to get back free? Well, what if I tell you there's a way for us to get back free? Okay. Firstly, we need to go to the courts. And yes, if you think we can do this without going to court, please show me a route. If you think we can do this without going to our legislators, show me a route. Because I don't believe it exists. Okay? One thing I definitely think that has to be done is we have to distinguish roads for commercial and distinguish roads for private travel. One of the issues that sovereign citizens fail to neglect to tell is, yes, you have the right to travel. You can travel any way you see fit. Foot, horse, bike, motorcycle, cow, donkey, automobile. You can drive. You can word it as a driving. You can travel by any mode of conveyance necessary according to the United States Constitution. The Supreme Court has ruled over and over again that no free liberty can be converted to a privilege. Now, the Supreme Court has ruled that if a state or federal government creates a privilege, it goes against your constitutional right. You have the right to break that, violate it, void it. It's null and void of contract. You have the right to sue the state or federal government for specific performances if they try to punish you for going against that null and void law. However, this is where the sovereign citizens fail to neglect to teach you. Okay? What they don't tell you is you can't do that on state maintained roads. Okay? Let me repeat that. You can't do none of that shit on state maintained roads. Okay? You cannot do it. It's illegal. And what I mean is, there's a saying, what is legal isn't necessarily lawful. Now, the states take taxpayer dollars and they go and they fix roads, okay? They put asphalt on them. They fix the roads. When they done that, they erroneously converted them roads into roads they can regulate by saying, oh, we maintain these roads for commercial usage and we have a right to ensure the safety of the public. Therefore, right there, they can regulate it. But you notice there's no roads outside of state maintained roads for the public to travel freely without hindrance from the police bothering us. Right there is an issue. How can I travel via an automobile down the road without being bothered by police if there's no roads left for me to travel on because the state quickly and vehemently went and converted those rights and all the state went and took those roads, all the roads that we had to travel, and paved them so that way commercial cars can get there. Right then and there, well, now you're automatically under their regulation because they don't know any better. And then, top it off, in the 60s, the courts merged together the civil and criminal courts to save space. So therefore, they blurred the lines with vague phrasing and wording, so it's very ambiguous. There's ambiguity in the language. So, how can you travel privately down a road if the state converted it to a privilege by paving it? That's what we're going to talk about today. Alright? Firstly, we got to get the language changed. Okay? We cannot continue on down the path that we're traveling with the vague language that they're using day in and day out to entrap you. The sovereign citizens do touch on a proper point. There is administrative courts. And what I mean by administrative is they're quasi-judicial. When they write you a citation, if you look on the side of the citation, it says you must appear in court on a specific day. If not, you can go to jail. So it's criminal. But most traffic infractions don't carry criminal penalties. They carry civil fines. So it's not criminal. they issue a criminal summons, but they penalize you civilly and lawsuit. And they violate due process because a police officer is an executive officer. He doesn't issue. He's not an issuer. A magistrate or a judge must issue a citation or a summons. But on the side of the road, a cop does it. Right? So they're monopolizing the roads when they do the asphalt and the expansion of the state regulated roads. So right there, they're taking away our roads, and they're taking away our infrastructure to travel freely, okay? All right, we need to go to court with multiple lawsuits, and we need, multiple people to do it at one time is what we need to do to get it all done in one shot. But we need them to distinguish in language, legal language, private travel from commercial travel. Sovereign citizens touch on a good point is police do use the UCC, the Uniform Criminal Code, to charge everyone as if they were commercial. But we're not all commercial. Paper says we need to propose the creation of a separate infrastructure and new legal framework for defining commercial from private travel. And I even propose separate roads, okay? I think we need non-state regulated roads. If the people want to maintain them, we can maintain them ourselves. But we need roads that are defined for commercial travel only, and where there needs to be a commercial vehicle traveling in the cities and things, they're already labeled as a commercial vehicle because they have DOT numbers on the side. Okay, so we know what they look like, whether they're small or big, it don't matter. The identifying problems is overregulation, loss of public access, excessive state interference in non-commercial activities. They are overregulating us. We need a separate infrastructure and new legal frameworks, period. There is some type of traveling that just is dangerous. So we have some form of aspect that is criminality. We can't remove all aspects of regulation from private travel because not all private travel is going to be safe. Because that's something that causes an issue, for the Constitution is there's always going to be someone who does not want to give another person free liberties as well. There's always going to be an individual that's like, oh, my right trumps your right, and fuck you. There's always going to be that. There's no getting out of that. But what's the best course of legal action? There ain't one case, but it's very strategic, multi-pronged legal political movement. And believe me, it needs to be loud and proud. We have a very conservative government right now where we can push for change. We need to use that to our advantage. We need a constitutional civil suit. We're not asking for money. We're asking for injunction of relief and declaratory relief. And we can go to the federal courts, and under 42 U.S. Title 42 U.S. Code in 1983, the civil rights violation. We can go and argue there's been an overbreadth of regulation, of transportation regulation, that now impedes on the right to travel. And it's an argument we can win every day. The courts use this overregulation to punish us through fines, and they're reaping in the benefits from it. But that isn't right. We need to ask for the systematic removal of non-regulated roads because it's an unconstitutional denial of access to a fundamental right. I wouldn't have a problem riding horseback everywhere, but dadgummit, it's way too dangerous to go from where I'm at in Wyoming to Grand Junction on a damn horse, because I go by roads where speeds can be reached 80, 90 mile an hour. That's dangerous. Y'all can't do that. The states have used language to blur the lines between commercial and private travel, and blur the lines between civil and criminal court, leading to unconstitutional burdens on the private citizen. We would seek a declaratory judgment recognizing that the right to private travel exists and must be accommodated. An injunction requiring state, federal to create or preserve unregulated roads or at-risk non-maintained roads for private travel. Now, we are going to have some issues. Courts have repeatedly upheld that the state's power to regulate public roads, especially under the police power doctrine. Okay, so we're going to have to argue very well, but, you know, we do have the right to defend ourselves, so we should have the right to travel on non-regulated roads. We would need to show a compelling historical legal case that removing or regulating all roads effectively eliminates a constitutionality protected liberty. We can do that. There should be a defined way or infrastructure for us to use our license to drive vehicles for Uber and delivery vehicles and things like that. I should easily be able to get in my car and drive from California to North Carolina, or North Carolina to Tennessee, without being pulled over by one police officer or even seeing a cop. There should be plenty of roads where you just shouldn't even see a police officer because ain't nobody out committing a crime. You know, drive at your own risk. I don't need regulation. You know, the states might have the power to regulate public roads. I don't want to travel on public roads because I don't want to be around the damn public. I like riding the back roads because for me, the scenic route is the quiet route. But, you know, I understand public safety, but that's also why, you know, you carry a goddamn gun. Someone tries to kill you, you kill them. You know, at the state level, you know, the public trust doctrine challenge. You know, we'll have to argue original routes used for centuries, old wagons, native trails are part of a public trust and should not be co-opted exclusively into commercial public maintenance systems. And again, you know, like I said, commercial needs to be regulated on its own roads. It needs to be somewhere else completely different. You know, we don't need commercial vehicles on every private road, every public road. We shouldn't have all of them commercial vehicles. And I'm all for downsizing, you know, to keep some of the big commercial vehicles off the back roads in the rural areas. Let's downsize to, you know, use let's use, you know, 1-ton trucks to haul what we can. people traveling privately. I mean, they have a clear reason, and that's because of drugs and illegal activities. So they have a clear reason to want to regulate every damn road. But that is a clear violation of your constitutional right. That's a clear violation of your right to free travel, because now that's regulated, no matter what, they can't use that as an excuse, because there's always going to be bad people. I mean, we have laws that say thou shalt not kill, and you know what? People still kill. We got laws that said you cannot rob, but people still rob. We got states like Chicago, cities in the states of Illinois, in the state of Illinois. We got cities like Chicago, Denver, perfect example. You can't open carry a damn gun around there, but yet people still getting shot left and right. Laws don't stop the criminal. And I ain't saying take all the cops off the road neither. I'm okay with a cop or two in the back roads. You know, you ride down the road there and someone drinking, I ain't got a problem with them getting pulled over. You know, because drinking and driving, I've done it for many a year, and I've always rode the back roads, you know, and stayed off the main roads because I knew there wouldn't be no wife and kids on the back road. At least not when I was out, you know, crawling around. You know, shit, I'm sorry. I got zoned down on the guitar. But, you know, let's get back to it. You know, court order rectification or reopening of certain routes for private use. You know, I'm all for it. And like I said, you know, I ain't got no problem with cops staying on the back roads, you know, watching for certain illegal activities. Like, you know, obviously there's going to be an issue with human trafficking. You know, so we're going to need cops out there looking for that. And nobody's saying take the cops off the road and stop all illegal activity. Because you pedophiles, you better hope that it's a cop, not me. You snatching up children, for kidnapping little young girls, for drug trafficking and all that shit, you better hope that it's a cop, not me. We want to keep the cops on the road, you know, and it will be used as a one's own risk, you know, because there won't be no licensure, insurance laws, or nothing like that. And we're not talking every law. We're just talking about specific laws. I don't need to be fucking licensed and registered and show competency and have insurance on a road with a bunch of fucktards. Now, don't get me wrong. Out of my own intelligence, I will keep insurance in case a retard bumps into me and takes off. You know, I think anyone traveling down the back road ought to do that. But let's be real. You shouldn't need it. When you're privately just going down the road, you shouldn't need it. And there should be plenty of roads that people can travel down that they're not bothered with by, police going, oh, you ain't got no license or tags. Okay, well, so what? I don't need it down this road, I'm all for the recognition of a class of at-risk, non-maintained public roads, because people like me or are willing to go out there and work on the roads and help maintain them privately, but also there's people with bobcats and tractors and front end loaders and motor graders that are willing to do the work too. We had perfectly fine roads before the government, and we can do it again. Parallel to litigation, legal suits alone ain't going to do it. We need people that know how to lobby state legislators. We need them to create a dual road commercial versus private system. We need insurance and titling reforms. That's been needed for a long time anyway. You should only be legally allowed to title a commercial vehicle. We need the ambiguity and vagueness of the laws rewritten so that way there's clear definitions of private conveyance versus commercial motor vehicles. Model legislation, it clearly defines drafting model legislation. We require clearly defined private travel and protections, establishing funding and planning for non-commercial routes. That wouldn't be hard to do because so many people would go off of the main roads, they would be willing to donate money. Groups that we need to consider teaming up with: constitutional travel right advocates, sovereign citizens. There's a lot that we can do together, but the way that y'all go about it, it's never going to work for us. It's just not going to work. That the route that y'all go only causes more headaches in the court system. We need to talk to property right foundations, libertarian and homesteader networks, because people are willing to allow some of their, a pathway through their property to go around a main road. People don't mind that. Amish and Mennonites, they have extensive experience fighting in road use limitations. We could consider a quo warranto. If we can prove that DOT or a municipal authority is overstepping the charter, they've closed all of our historic routes to arbitrarily. They've denied our access to unregulated paths. One of y'all super duper special legalese experts could probably word that correctly and fight it. Marbury versus Madison. You can't convert a liberty into a privilege. Marduk v. Pennsylvania. If they do, you can disregard it. Shuttlesworth versus Birmingham, Alabama. If the state punishes you, the state can't punish you for violating a law that goes against your constitutional liberty. They can't punish you for it. The Supreme Court has ruled that even automobiles can be used as a mode of conveyance. The Supreme Court has consistently ruled that the states and the federal government cannot take away your free liberties. What do we need the license for to go fishing? How come? Explain that. That's a regulated thing now. You can't go fishing without a license anymore. And if you try to go to court as a living man and fight it like a sovereign citizen, your ass will get smoked. You can't hunt for food anymore without a damn license. These are all regulated liberties. Every liberty of the Constitution, one way or another, is regulated some way, somehow. You know, another issue that we'll have is finding proof of specific injury, like landlocked property due to regulation or legal inability to travel without engaging in commerce. What city, how many cities can you, major cities can you go from one major city to the next without touching a state maintained road, proving your inability to travel without engaging in commerce? We'd have to do administrative rulemaking petition. In states with administrative codes, we need to file a petition for rule change to require agencies to reassess designation of roads, acknowledge and preserve commercial, non-commercial use roads, and redefine motor vehicle to exclude private conveyance vehicles used off-road regulated, off-regulated systems. The Corpus Juris Sectum, Volume 20, Section 1785, inasmuch as every government is an artificial person, an abstract and a creature of the mind only. And this is for sovereign citizens. A government can interface only with other artificial persons. The imaginary, having neither actuality nor substance, is foreclosed from creating or attaining partly with the tangible. The legal manifestation of this is that no government, as well as any law, agency, aspect, or court, can concern itself with anything other than corporate artificial persons and the contracts between them. SCR 1795, Penn Hollowell v. Doan's Administrators. Okay, that's very, very powerful. Okay, every government is an artificial person. Okay, an abstraction and a creature of the mind only. A government can interface only with other artificial persons. The imaginary, having neither actuality nor substance, is foreclosed from creating and attaining partly with the tangible, parity with the tangible. The legal manifestation of this is that no government, as well as any law, agency, aspect, or court, can concern itself with anything other than corporate artificial persons and the contracts between SCR, between them. Okay? That is huge. Huge. Okay? It's huge. And I forgot to pull this one. Establishes the principle that statements of counsel in brief or argument are not facts before the court and cannot be used for motions to dismiss for summary of judgment. The court held that the plaintiff's attorney, by not presenting proper witness testimony, violated the rule that the attorney cannot be both an advocate and a witness. As a result, the court rejected the attempt to introduce evidence without adequate support from a competent witness or admissible affidavits. Okay. Federal Rules of Civil Procedure, 12b6, motion to dismissal. Let's see, most important topics in civil procedure and one of the most discussed on law school exams. Okay. Pertains to the pretrial motions, specifically deals with motions to dismiss for failure to state a claim upon which relief can be granted. Okay. And that's what a lot of, like Carl Miller, when he discusses, this is what he's talking about. The state takes you to criminal court for a civil case, and this is what he talks about. You go in there and you tell the judge, Your Honor, how may we see a civil equity infraction in a criminal court? I motion to dismiss for failure to state a claim for upon which relief can be granted. Okay, motions are rarely successful, and when they are, their success usually has more to do with the judge than the law. Nevertheless, they appear regularly in law school civil procedure exams and bar exam civil procedure questions, so it's important to be aware of them. Required elements. Failure to state a claim upon which relief can be granted can mean a number of things, all of which have to do with what is stated in a complaint. First, and most typically, the complaint failed to properly allege one or more of the required elements of an action. And here's what I mean by this. Suppose someone files a complaint for negligence. In that complaint, the plaintiff must allege all the elements of negligence, and the elements must be applied to the defendant or the defendants. For example, in the above negligent suit, let's say the defendant hit the plaintiff with a car. The plaintiff would have alleged all of the elements of negligence and apply them to the defendant, such as the following. Defendant owed to plaintiff a duty of care. Defendant breached that duty of care. Plaintiff suffered injuries. The injuries were the result of defendant's breach of duty. As mentioned earlier, motions are rarely successful in no small part because pleading requirements are generally quite liberal. In spite of these lax law requirements, however, the above pleading example would be insufficient to defeat a 12b6 motion. The bare legal conclusions. The pleading is insufficient because all it does is, in court parlance, merely recite bare legal conclusions. The complaint must do more than this. Specifically, a factual basis for the claim must be established by the complainant. Using the same example as above, the complainant must also include details about how the defendant was negligent and how this negligence caused the plaintiff injuries. Perhaps the defendant ran a red light and collided with the plaintiff's vehicle or the plaintiff herself. Perhaps the collision caused the plaintiff to break a leg or worse. Complainant must contain factual allegations such as these to be considered as having stated a claim upon which relief can be granted. If that claimant doesn't put in hit my car and broke my leg or this or that, it's void, and you can't enter after the fact. So it has to be entered from the start. Furthermore, the factual detail that can be included in the complaint, the better. One reason for this is to ensure that you have sufficiently pleaded the elements of the causes of action listed in your complaint. Another reason, and an important one, is the standard that is used to review 12b6 motions. Specifically, when deciding such a motion, the court assumes all factual allegations contained in the complaint to be true, giving the plaintiff the full benefit of the doubt. Recognizing this, it is vital to include every fact that could, in any way, be relevant to give the court as complete a picture as possible. Even if you have perfectly pleaded the elements of a given cause of action, included a complete and detailed set of facts, the 12b6 motion could succeed nonetheless. Although less commonly the reason for success of such a motion, the court could decide that the pleaded cause of action isn't recognized by law. Using our car accident example, if the plaintiff claimed assault and battery instead of negligence, but all the facts remained the same, the car accident truly was an accident, and there was no intent to cause injury to the plaintiff. Then the 12b6 motion, at least, in regards to the assault and battery claims, would succeed. Practically speaking, the judge would usually give the plaintiff leave to amend if a legal cause of action was apparent from the facts, but 12b6 motion would still technically be successful. In any case, it's important to make sure that the facts alleged to complaint are well supported and accurate. Save yourself time and find mistakes before they happen with more efficient legal research from Rose. So, we'll be back later, and we're going to be talking about traffic citations, errors, and ways to fight them, and legal defenses against them. Okay?